Good morning, everybody. My name is David Churchill. I'm a third-year law student here at the law school. I have the privilege of introducing the very first panel for everybody today. First panel is entitled Federal Deregulation and State Roles vis-à-vis Telecom Networks. And I think this is a really great way to connect the things that Professor Gulasekaram was just talking about into the world of telecom. I think when there's a new federal administration, there's lots of changes, and there's necessary questions of what states can do and what roles they should or shouldn't have. So with that, I would like to introduce our panelists. First, this panel is moderated by Professor Jonathan Nuechterlein. He's an adjunct professor of law at Georgetown University Law Center. As for the panelists, we have Christopher Yu. Christopher is a professor, the John H. Chestnut Professor of Law, Communication, and Computer Information Science at the University of Pennsylvania. Then we have Michael Santorelli. He's director of the Advanced Communication Law and Policy Institute at NYU, at New York Law School. Then we have Nick Alexander, senior policy advisor of Quadra Partners, LLC. Misty Giles, who's the Chief Operating Officer and Director of the State of Montana's Department of Administration. And then lastly, but certainly not least, we have Arpan Sura, who is the legal advisor to Commissioner Carr and the FCC. So with that, I'd like to turn it to our moderator, and I look forward to the discussion.
Hi, everybody. It's great to see everybody here. I started coming to these conferences in the year 2000. I was one of the original participants in this program. And when I arrived here, Phil Weiser was a new professor at CU. And he had just written an interesting paper. It wasn't yet published, but he was still receiving input on it. It was a fascinating paper, and guess what it was called? Towards a Constitutional Architecture for Cooperative Federalism. And this conference, 25 years ago, was largely about issues of cooperative federalism. The iron was really hot for Phil to have written that article at that time because the big policy debates of the day related to the respective roles of the federal government and the states in implementation of the then somewhat recently enacted Telecommunications Act of 1996. For those of you who are old enough to remember, the 96 Act contained market opening provisions for local telephone markets. And the innovation in the Act was largely to replace a scheme of dual regulation, dual federalism, with a new scheme of cooperative federalism. Now, we heard those terms from Deep earlier, and we're going to hear more about them later today. But in a nutshell, as they pertain to telecommunications policy, back in the day, back before the 96 Act, there was a wall between topics of federal concern and topics of state concern that was only occasionally breached. So the federal government had effectively, though not literally exclusive jurisdiction over what was called the interstate component of telecommunications networks and services. And the states had independent jurisdiction, and they were immune from federal intervention in the intrastate components of telecommunications regulation. As I said, we're going to hear a little more about that later on, but the important point I'd like to underscore is that the 96 Act was sort of a milestone in federalism policy in the telecommunications field because whereas previously you had divided the world up into these separate spheres, the Telecommunications Act created federal law that would be co-implemented by the federal government and by the states. As it worked out through the course, the FCC at the federal level was given essentially the job of specifying the methodology that would be used for regulating local competition in telecommunications markets, whereas states would be given the job of implementing federal law while taking binding guidance from the FCC on those issues. Now, some of you may also remember that the the role of the FCC vis-a-vis the states was a subject of intense dispute for several years. It went up to the Supreme Court, and by a vote of 5-3, the court ultimately upheld the FCC's methodological role in setting the basic rules of the road for local competition regulation. Well, to paraphrase Mark Twain, history may not repeat itself, but at least in the telecommunications field, it does rhyme. Now, our panel today will explore two basic topics of federal authority and the respective roles of the federal government and the states. In one context, the federalism is highly cooperative, sort of. In the other context, it's rather uncooperative. So the first one involves a new piece of legislation enacted in 2021 that bears striking similarities to the 96 Act in the way that it addresses the roles of the federal government vis-a-vis the states. So under the BEAD broadband funding program, NTIA, an agency of the federal government, sets the basic rules of the road for how federal funds will be dispersed for broadband deployment and adoption, and the states play an implementation role. And the exact line between NTIA's role and the state's role has been the subject of great controversy, as we'll discuss later. The other main topic we're going to talk about today is the interesting predicament that we find ourselves in now that the FCC has more or less been conclusively deemed to lack authority to regulate broadband internet access service, and specifically with respect to net neutrality rules. Several states have entered the field and have imposed net neutrality rules of their own, and 3 courts now have concluded that the federal government's decision to divest itself of authority over broadband internet access service has a logical consequence of precluding federal preemption of corresponding state laws. So in that context, and that is also a hotly disputed issue, and there's a petition for reconsideration pending at the Supreme Court concerning that very set of issues. So news is unfolding as we sit here today, but we're going to hear from our great panel about the various theoretical and practical issues that these models of cooperative federalism have given us. And first, I'll turn to Michael Santorelli.
Great. Well, thank you, John, and good morning, everybody. It's such a pleasure to be here. Thank you to Brad for inviting me to participate, and thank you to the organizers who've done a really great job of making it very easy for me to participate. So I'm here to provide some scene setting, some very high-level thoughts, and to situate our discussion in what's happening now. John teed up a lot of the dynamics that are happening. I'm going to frame my remarks around this question of, is state regulation of broadband harmful? And to answer that question, I'm going to look back a little bit at the past to understand what's happening now and to give us maybe some guideposts as to what might happen down the road. So John touched on a lot of this. So what we're seeing currently are a number of states seeking to fill this perceived regulatory void that was opened by the FCC in, should be 2018, not 2017, in its Restoring Internet Freedom Order that reclassified broadband as an information service. Previously, it had been reclassified as telecom service. That had been an ongoing flip-flop for several years. And then the FCC order, the FCC's interpretation of the Communications Act was that essentially it has no authority to regulate broadband. That's how it removed that, and how it justified its reclassification. And so courts have interpreted that as a federal abandonment of the field, opening the door to states. And as we've seen, as John mentioned, a couple of states have already kind of walked through that door. California had passed a net neutrality law in the aftermath of the 2018 FCC order, essentially codifying the net neutrality framework that the FCC had undone. That was upheld in a Ninth Circuit opinion. And then a few years ago, New York, my home state, passed an affordability law that set a price for broadband for certain customers, tantamount to rate regulation of broadband. That was challenged in the courts, and that was upheld by the Second Circuit. And ever since, and Christopher will talk about those cases in more detail during his presentation, but since then we've seen some ripple effects across a number of other states. States that have adopted their own net neutrality laws, state public service commissions, the state regulators that oversee mostly electric and water services have started to poke around to regulate VoIP services, voice over internet, IP-enabled services, which I've included in here to kind of reinforce this notion that states are increasingly exploring the outer bounds of their authority. So is this a big deal? So on the one hand, as John mentioned, this kind of state-federal tension has been a defining characteristic of the communication space ever since the FCC was created, 100 years ago. And states have long played a very active and important role in the telecom space beyond traditional regulatory roles around things like rolling back or adjusting their legislative frameworks to accommodate new investments in new networks and things like that. And then in the past, Congress has been relatively responsive, and that should be, big quotation marks around relatively responsive, especially relative to today, where, as Deep was saying, federal stasis is a nice way of putting it. Congress was somewhat more responsive to changes in technology and offering a little bit more clarity and guidance around this state-federal balance. But on the other hand, as I'll talk about a little bit later, what's happening now is different when viewed through this context of the traditional or the evolutionary regulatory federalism that we've seen in this space. So John touched on this in his opening remarks, the shift from sort of the dual federalism model to the cooperative federalism model from 1934 to 1996. But as I mentioned, there's always been tension between the states and the federal government. It's never been a very clean relationship in terms of identifying those boundaries. There have been any number of disputes in the 30s, 40s, and 50s around the, this is a very nuts and bolts type thing, but identifying the traffic over these systems, what was intrastate and what was interstate, and that was a key issue for setting rates at the state level and at the federal level. And there's a lot of tension between the states and the federal government over those boundaries and the extent to which states could set rates higher or lower depending on where that boundary was. And then the 1996 Act came along, implemented a more cooperative model, but even there the FCC still retained a good amount of authority over state actions to guide their implementation of the Telecom Act, which included a host of things that the states had to do in creating local telephone competition. So this dynamic that was created over the course of those several decades was evident in how states responded to new technologies that emerged. And the examples here are cable and wireless. So you had states that had developed significant expertise and experience in regulating the intrastate elements of certain networks and services. And then as cable and wireless came about, cable in the 50s and 60s and wireless in the 80s, states reacted by trying to extend their jurisdiction to those services as well, regulating cable rates, regulating wireless rates. And then eventually the FCC stepped in and Congress stepped in a little bit later to offer in both cable and wireless a more federal or national framework for these services as it became evident that these were national services, but also carving out specific roles for states, more modest roles for states. Now turning to the more recent history of broadband, and I've again included VoIP in here, or IP-enabled services, it's been a little bit different over the last several decades. There's been some appreciation among the states that these services are different, given their technical capacities and makeups are different than the traditional telephone network. And that's been evident in the fact that about half the states, the count has fluctuated in recent years, have deregulatory laws on their books that prohibit their state regulatory commissions from regulating these services, broadband and or VoIP. And at the same time, a lot of states have acted in response to these new services to roll back legacy restrictions on telephone companies in particular, recognizing that there's been a significant transition away from plain old telephone service to IP-enabled services, broadband, freeing up some of those, in an attempt to free up investments in new networks by undoing legacy regulations, and then also updating their laws to streamline things around rights-of-way access and things like that. But we've had a number of states that have continued to try to regulate these services. So how is it different now? We've seen this dynamic before where it seems like this is part of the same kind of dynamic as in the past. But what's different now is that state actions are happening at a much later point in the development of these markets, whereas previously in like cable or wireless, states came in very early on, these new services, trying to figure out what their role was. Now we're at a broadband market, IP-enabled services market is very mature. We're at essentially universal service. And so regulatory attempts now could have significant impacts on service providers who have relied on this sort of notion of light touch regulation for decades. The services are a lot messier in terms of separating out this boundary between state and federal jurisdiction. That's been a key point of contention in a lot of these cases, if there are intrastate elements of these networks. The Communications Act is severely outdated with respect to these services. Chevron is dead, rest in peace. And that gave the FCC significant deference and latitude to interpret that antiquated statute in some of these contexts, and now that deference is gone. And perhaps the biggest development over the last 20 years has been that these issues have become politicized. I don't remember TELRIC or UNIP being a big poster, things people protested about after the 96 Act, but now over the past 20 years, think about net neutrality and how it's seeped into the public consciousness and public culture, pop culture. That's never happened before in the telecom space. And that's really informed a lot of the actions at the state level and in federal level around these issues. And then also BEAD, NTIA allowing states to use that program as a way to layer on additional rules and requirements. So I'm being told I have to wrap up. So what's the worst that could happen? So cue the parade of horribles, but in reality, we've already seen some harms from these state actions in the broadband space to regulate. The New York rate regulation law has driven out one ISP already. Others have sought waivers of that enforcement of that law. So if they don't get it, who knows, they might leave too. We've seen laws in other states be proposed in Massachusetts, Vermont, California. A number of other states have voiced support. Any number of additional harms could follow. And then what needs to happen? I think we're going to talk about this in our panel, but certainly congressional action to provide some clarity as to what is broadband and what's the regulatory authority and responsibilities for states and the FCC. It'd be nice if the Supreme Court could weigh in. FCC efforts to navigate this very complex field in the Loper-Bright era. We'll see how that works out. It would be interesting to hear Arpan talk about that. BEAD reforms are needed to remove a lot of these state excesses, and then refocusing state efforts where there's a lot of things that need to be done, and then you can ask the question of whether regulating broadband is needed in this environment. So I'll just leave it there and leave the rest for our panel discussion. Thank you.
Christopher, you.
Well, thank you. It's an honor to be here. Thank you, John and Michael, for doing such a great job setting the stage for what I would like to talk about today. And it's a particularly good use of my remarks in the context of this framing would be to do a deeper dive into one of the particular issues. We could keep talking about this at a very high level, but really, how does the federal-state allocation of power really play out in the context of one particular issue, and particularly framing it in terms of the idea of our panel is in a world of deregulation, how does it play out in particular? And so that's what I'd like to talk about today. And the focus of what I'm going to talk about is an issue that's been near and dear to my heart for a long time, and that's the issue of net neutrality. It's kind of ironic that I talk about this here because I've been writing about this for about 20 years. It began here. In 2004, at this conference, I was asked to give the response to Tim Wu's, the article he wrote for the journal here, that is credited with coining that phrase. I mean, a lot of people will dispute that we've been talking about it before then. I was asked to write a response, he wrote a reply, and we've been off to the races ever since. We put a dialogue that many people use, and it got published in the Telecommunications Law Journal, and it became ultimately the gift that keeps on giving to a career academic like me. So I do share some of the responsibility for getting this fight started. I refuse to take the blame for how long it's gone on. I've been predicting the death of this argument since 2007. And let's put it this way. If you want me to hear my advice about whether the Eagles will win the Super Bowl, that prediction will be worth every penny that last one is in 2007. So anyway, I just thought that it's particularly appropriate for me and for it to come full circle and to talk about this. And to really think about this in the context of deregulation, because I think it actually presents some really interesting things. So first, I think this has fallen under the radar because with the Sixth Circuit decision invalidating the Biden-era 2024 what's called safeguarding order that basically rolled back to the 2015 open internet order. Effectively, that essentially took us off the books and left in place what was before, which is the 2018 restoring internet freedom order done during the first Trump administration. And talking to a lot of my friends, I say, okay, people who like the outcome of there not being net neutrality think we're done. We've got the outcome we're looking for. We don't have to do anything else. And I think that's not quite right. That's not quite right because of three circuit court decisions that very clearly establish that the 2018 order did not preempt state action in space. So we have a DC Circuit decision in 2016 I'm sorry, not the 2016. This is the actual later one in 2024 where, 2019 order, anyway, the Mozilla decision, which John had the good luck to argue, if that's correct, clearly said that this didn't preempt. That didn't preempt state action in the space. Taking that invitation, California basically reenacted the 2015 order. Even though it's almost chapter and verse what the FCC decided not to do. And the question is, was that conscious decision not to do something, did that have any preemptive effect on California? Answer, no. And then the state of New York, as in the decision that both John and Michael alluded to, actually has passed regulation in the name of affordability that essentially rate regulates all ISPs, last mile ISPs, regardless of the amount of competition they face. And so and that was also upheld by the Second Circuit, initially struck down by the district court as being preempted, but that in turn was reversed on appeal, and they said, in fact, that's not preempted by the 2018 order. So we see in this world a clear idea that if we just stand on the 2018 order, it opens the door to states to engage in broad action, if not actually undo what the FCC did. And for people who are interested in this, there are many people who think that we should have uniform policy in the broadband space or internet space. This is potentially problematic. I mean, that's the question that we have to think about is, in this world, how do we navigate this in a way that might actually lead to uniform federal law? Or if you like this result, how would you construct arguments on the other side to try to maintain the status quo? Okay, so under core preemption, as many of you know, preemption has many flavors, and this is a horrible, horrible area of law. It's students' nightmares in terms of getting through it. So I'll try to break it down, not at the level, if this were legal advice, it'd be followed by a bill. So, I mean, the answer is this is just sort of my boil down of the big considerations, particularly as framed by these cases. And for federal law to preempt state law, there has to be two things. One, there actually has to be a conflict between federal and state law. It can be an explicit saying, a weird setting aside state law, or it can be implied by saying, well, they didn't say it in so many words, but you can't do both at the same time. There's a limited thing called the impossibility exception that you can't separate them. There's all these different things, but there has to be a conflict between federal and state law. In addition, for the federal government to preempt state law in an area, the federal government has to have, or the agency in this case, authority over that area, because you can't preempt law in areas you don't have jurisdiction over. And so both those things have to be true. And in fact, both those roles played a significant impact on all three of those preemption decisions we get. So what's fascinating to me is a couple things, which is that there is a deep interaction between these two levels, which is if you lack authority to do something, you can't explicitly do anything that would conflict with it. And so in fact, you have a tension here. But what's more interesting to me is that in fact, in a deregulatory context, conflicts are are much harder to demonstrate. Why? If you're not doing something, how can you say that not doing something conflicts with someone else doing something. Unless you're going to create some sort of shadow of inaction, which we do for the Dormant Commerce Clause and a handful of other things, but we really don't like doing. I mean, in fact, we generally tend to interpret it against that interpretation. And that what we see here is that you're going to have an inherent limited ability to find implied conflicts when your basic position is we're not going to do anything. Now, you could do it only by some sort of explicit displacement of field or what they call field preemption or other things, but that's harder to do and can often be construed around, particularly in a world where we are trying to give federalism as ample room. In terms of statutory authority, what's interesting here is the FCC has got itself in a bit of a catch-22, which is in a deregulatory world where you're not just affirmatively deregulating certain aspects. If you're disclaiming regulatory authority over areas, it limits your ability to preempt in those areas by definition. And so what we have here is a decision by the FCC, now upheld on the Sixth Circuit, and apparently not going to be appealed by the current administration, saying that broadband internet access service is an information service, not a telecommunications service. And I think, in fact, on issues of preclusion and all that, the government's going to be bound by that because they had the chance to pursue that. And if they don't, that's it from their standpoint. Whether private actors can go, different question. You're going to have to find a statute that's going to give you authority over information services. Not over things generally, but because it's no longer a telecommunications service, you can't rely on any of those traditional things. Okay, so it's an interesting set of problems augmented by ancillary jurisdiction. So what do we do? What are the possibilities? I see there's sort of three being talked about. One is Section 706, which was upheld by the DC Circuit in 2016 and the USTA decision as a basis of authority because it used the word shall. This is a pre-Loper-Bright decision, so this is a time where we're giving a lot of deference to agencies. Whether that would in fact hold up under modern doctrine is not yet clear. But more importantly, the current chair did not like that rationale at all. So even if this were potentially open, politically, I don't see it very likely that Brendan Carr will push through an order. He does not clearly has a preference for going that route. So it's out there as a sanctioned avenue, but it's a problem. And so we have then, what did he rely on in the order he joined in 2018? The market entry barriers requirement of 47 USC 257, which basically says the FCC had an obligation within 15 months to do a proceeding to remove regulations that created entry barriers to small and medium small businesses and entrepreneurs who wanted to provide ISP services. And at the time, it had a provision of a triennial review, which required the FCC to have an ongoing evaluation of that. And that became the basis, even though it had been long past the time this was initially passed, the triennial review gave the FCC the hook it needed in the 2018 order to say, we can continue to regulate in this space. In 2018, Congress eliminated the triennial review requirement. So now it's a one-off requirement that has long since expired. And this puts a big limit on their ability to go that route. Third option that people talk about, John and I were talking about this at dinner last night, everyone loves Section 230. We can talk about what its purposes were and all this. But, if you look at the operative provisions, we have findings, we have policy, we have a DC Circuit decision that says policy does not make preemption. The law makes preemption. Policy is what you plan to do. And if you look at, the definitions of publishers and the Good Samaritan restrictions, how that's going to get you to net neutrality is not clear to me on the face of the statute. And so I look at these candidates, and it's not at all clear to me there's an obvious basis. I literally looked at Title 47 for every instance of the reference of the word information service and did not find a single candidate. So basically, in a world where it's not a telecommunication service, it's not clear what statutory basis the FCC has for establishing uniform federal law and by preempting state law here. And so that's not to mean that there's a lot of lawyers in DC who are about to get paid a lot of money to find out how to do this. I'm not saying that they're not going to find it. That does happen, but on a quick look, for a person who doesn't do this for a living, for trying to make this go for a particular client, I don't do that. So basically, my summary, I don't think there's a good chance the SEC may not be able to just stand on the 2018 order. It'll leave states free to do what they want, in which case you'll back into the same result. Just have to lobby 50 states instead of one large federal government, and with all of the pluses and minuses that go with it. Have to find a statutory basis or get new authority for Congress. And this is so funny to me because with the deference swinging back and forth, we said, well, we need authority. Okay, now Chevron is dead. We don't need to do that. Don't need new legislation. Well, if you want to preempt, maybe you do. And it's a really interesting problem. States could reimpose it otherwise, and we're going to see this come up more and more. This is a feature of a deregulatory environment, which is more likely to lead to a withdrawal of authority, which will create more room, an active deregulation, which minimizes conflicts, in which case you're going to see actually these kinds of issues, I think, recur in lots and lots of contexts. Okay. Just because I saw Michael's slides after I did mine, I can't help but make a couple of comments in the little side conversations we've had with people about other aspects of it aside from preemption, which is, shall we say, not everyone's cup of tea. A few moments about BEAD. You know, what you saw in the administration, I have a number of comments and they may come up in the Q&A, but the most fascinating thing to me was a huge preference for fiber to the home in particular, and generally a hostility towards satellite. And what's fascinating to me is I understand why, because if satellite's a viable competitor in terms of defining the scope of the problem, it's not clear you have a problem because it's basically national in coverage. And there's a political valence about people wanting to support different things. Regardless of whether you think that's a good idea, the politics look very different right now. The idea that the current administration is going to be as hostile towards satellite as the previous one is, shall we say, unlikely. And so the question is, what is likely going to happen? Well, setting aside how that all gets worked out in terms of defining the scope of the problem, who gets money, what's really fascinating to me is it's going to radically reduce the per household cost of serving different areas, unserved areas. And in fact, if you do the quick math based on how this is happening, many states have been allocated much more money than would be required if you connected them through satellite. And so there's likely to be a dividend. And the question is, what do you do with a dividend? And I know that the problem I do this globally. Regulators love building things. They love building infrastructure. That's what we always do. And if after that, well, we'll regulate rates. And what we've learned abroad, and it's true here when you drill down a little bit more, is that neither one of those is really always the problem. What you see is it's not building them. You have an enormous problem of adoption. So to give you a quick number, there's of the 8 billion people in the world, 2/3 are online. Of the 1/3 that is online, 80% have access to a network. So we could build out that last 20%, and we should. But that's not going to solve the problem for why those 80% that have access aren't on. This is about adoption. And once they're adoption, it's about utilization. You find people using very small amounts, they're not actually getting the benefit. The problem with this is regulators have very little experience doing this, and honestly, scholars have not been as much help as we should. We don't have a roadmap. But the fact that we don't know how yet is not a reason not to do it. It's critical. And so I think that, in fact, as part of this dividend funding, a great use of this would be to try to understand these barriers and overcome them. There's an old study by 2 FCC staff and a Kentucky outfit, and I've just dropped their names, Connected Nation, where they actually asked people who had subscribed to broadband, and they said 2/3 of them wouldn't take it even if it were free. And so there's actually a number of barriers we have that if we're trying to get people to realize these benefits that need to get addressed. I hope that comes out in our discussion. And with that, I give my time back.
Thanks to both Michael and Christopher for those remarks. I'm going to exercise my moderator's prerogative and ask a question before turning it over to the discussants to give their views on what we've heard as well as other issues on their minds relating to federalism. Here's my question to our two presenters. From a policy perspective, which really sounds more in the Dormant Commerce Clause than in preemption jurisprudence, it seems to me that there are two types of state laws in the broadband arena, and they should be, from a policy perspective, viewed differently. One type of state law has effects that extend beyond state boundaries. So I'm thinking here of, say, California's regulation of interconnection. You cannot regulate internet interconnection without affecting network architecture decisions outside of your state. The other type of state law is the one that Christopher alluded to that we see in New York, where the state legislature has required, with some safety valve provisions, has required all major broadband providers to offer inexpensive broadband service for low-income consumers. That state law has apparently induced one major broadband ISP to exit the market. It would have been a new entrant. This is AT&T's 5G product, 5G fixed broadband product. But the thing about the New York law is, let's assume for the moment, because it seems to be true that there are no obvious out-of-state effects of this law. Now, that may be subtly untrue, but it seems more likely to be true than the proposition that the California law had costs and benefits that could be felt only in California. So if that's the case, the New York policymakers had a decision to make. It's like, on the one hand, we want to promote broadband investment and competition. But on the other hand, we also want to make sure that our lowest income consumers are connected to the internet because that's a civil right. And we want to use this as our way of achieving that objective. It's policy balanced, has costs and benefits. But my point is, whether or not you agree with New York's decision, those are costs and benefits that are felt within the state. And there are political repercussions if the people of New York decide they didn't like that outcome. Should we view these two types of laws differently, at least as a policy matter, from a preemption perspective? Michael, I'll let you go first.
Well, thanks for the question. I don't want to take up too much time because you already heard from us enough. But so it's a good question. My initial thought is to say no, just because as you look at from a policy perspective now, it's hard to untangle policy from politics. And if you look at the ripple effects that have been happening as these states have implemented these laws, even if they are arguably confined to a state or arguably have interstate impacts, I think almost any action now at the state level has interstate effects, just given the political environment we're in. Certainly, if you look at the political profile of the states that have acted in this space versus the ones that have not, historically, it does divide down across partisan lines. In this new era that we're in of hyper-partisanship, it's hard to confine things to states. So I think that to answer your question, I would say no.
Christopher?
So I find the question kind of quaint. It's sort of one of these things where, it's like, when we learn con law, it's like federalism, Commerce Clause, yeah, that's a limit on it, and we've got cases since then, since Lopez and all that. But we see in this world a big difference in how we've handled this in network industries. Railroads we came to the conclusion that it's all federal. And we've done that with Spectrum for reasons that I still don't understand in telephone. On Smith versus Illinois, versus Smith, XRL, whatever, I can't remember, the 1930 Supreme Court case, we did it differently. And we have this notion that we can separate it. Anyone who does systems theory can really question whether this is separable, which is, if it's a system, you change the pricing on one part of it, you're gonna have effects. And there's just no getting around that. And so the idea
Are you saying that by lowering the prices in New York, you're going to cause the broadband providers to raise prices elsewhere? And if so, why weren't they already charging the profit maximizing prices in those areas?
So what's fascinating to me is, limiting the prices you're going to have will induce traffic that will create interconnection aspects. So it's not isolated to the last mile.
Sure.
And in fact, what you'll see, if you think about the whole justification for the old open internet order, the original one, was the notion that there's a deep interconnection between the last mile and the stuff that's in the middle, both an interconnection standpoint and the final end connections. But I was really, and at the risk of sort of stealing my own thunder and getting ahead of my conversation with Misty Ann, one of the things that I learned from one of my postdocs, who was a professor in Nebraska named Gus Hurwitz, who many of you know, he convened a lot of discussions about rural broadband. And what he discovered, he revealed to us, and I remember when some of the people who attended this conference, we got in conversations with them there, said, DC kind of has certain things wrong. We have a certain idea of what rural problem is and what it's not. Speaking specifically about rate regulation, the point was we had three areas. We had within rural counties, small urban areas that actually were served by conventional services. We had a collar around them being served by fixed wireless companies that wouldn't go if there were any competition and are so profitable that the private equity people kept trying to give them money and they kept turning it down because they're generating cash like crazy. And I've done some modeling on this and never published it, but it's astounding what they're able to accomplish, but they're able to be served. Then you have the hyper rural areas where they have nobody. And the problem is it's not a good business proposition. Their idea of rate regulating their rates is anathema. they're actually trying to find someone interested in having a conversation with them about providing them service on a private basis at any price. And for them, they don't want rate regulation. They actually want a fair deal, understanding that it's very costly to serve these areas. And that what we have here is a uniform, the idea that this wouldn't have effects, that shouldn't be taken into account, is something, it may be up to the voters in New York, but is from a policy standpoint, is going to have impacts all the way down that I think need to be chopped a little bit finer.
Okay. So we have been talking a little bit about, overwhelmingly, frankly, on net neutrality, and I think it's probably time to pivot a little bit to the BEAD program, which is the other major topic of discussion today. And I'm going to ask our discussants to address that in a minute. But in the meantime, I want to ask each discussant to say whether they have responses to what they heard from Christopher and Michael earlier. And I think we'll go with you first, Misty.
Sure, I'll jump in. So to the question about, kind of, is it two separate parts and can you make those distinct? I was making some notes. I would say you can't parse those out at the state level. For one matter, companies that go across all state lines, they weaponize that against us. I cannot tell you how many meetings I have from a Charter, an AT&T, or Verizon. I'm not calling you out specifically this year doing your jobs of, well, Wyoming's doing it, so you should do it as well. I'm not Wyoming, so I may not care. So it is kind of creates a different friction. And also another thing I've seen in Montana as my third governor, I've worked at both federal and state, is when one state does something like New York and the politics are different, those legislatures tend to be reactive unnecessarily. We have very different politics in Montana than compared to in New York, and so we're battling these issues, and the issue's not even there. And as it comes to rate regulation and things like that, like Christopher said, we're very anti that. We have locations that are $300,000 per location if you use fiber. And there's only one or two houses, if that. So if you start doing rate regulation and put cost controls, we can't get anybody to want to serve it. No one at all. There will be no internet.
So I guess one point of clarification, when you say rate regulation, are you including conditions on federal funding for broadband deployment?
I am. Montana's very against the low-cost provisions that are contained in the NOFO because they are rate regulation. I don't believe it's a contingent of you get the award, so you're signing up for all those conditions. It is price control. I think having a low-cost requirement, as the underlying statute requires, it says all companies must have a low-cost plan. That was what was envisioned by Congress, is one thing. Having states mandate a specific price and a one-size-fits-all approach is a whole nother.
So I'll just channel. Actually, I'm not going to channel it. I'm going to let. I'm going to turn to Nick to channel the Biden administration's response to that.
To the short stick.
So there is some irony in that, as the guy who has served as a legal advisor to 3 Republican commissioners at the FCC and the head of federal regulatory for a BOC. With that being said, I was also the director of policy in the Office of Internet Connectivity and Growth for the first 2 years of the BEAD program, so I do have some insight into this. At the macro level, and I think one thing that's really important to keep in mind that was just alluded to, BEAD is a federal financial assistance program. It is not its own independent statutory mandate. It is a statute that directed NTIA to create a grant program that had a whole series of requirements that included a way to set a budget, a variety of conditions that were to be attached to the funding, and then obviously a huge role for the states in implementation, subject to every step of the way approval of the Assistant Secretary at NTIA. So when Misty Ann says, and Misty Ann and I have talked about this, and we are friendly, this is all kosher.
I'm still on the Christmas card list.
We're good. When she says that the low-cost service option is rate regulation, that is antithetical to the words that are in the statute. 60102H5 says all of the states have to set a low-cost service option, and then at the end it says subject to the approval of the Assistant Secretary. Had Congress not wanted the Assistant Secretary to have the ability to put conditions around the shape of that low-cost service option, they would not have mandated that he approve each and every one of them. So there's a policy difference there, and you can absolutely argue that the Assistant Secretary should not have put as close a constraint around the low-cost service option as initially happened. And you will note over time that the low-cost service options that were getting approved in the initial proposals started to relax away from the model that was set forth in the NOFO. So at the end of the day, it's a grant program. Grant programs, by definition, are going to have conditions that are attached to the funding. That is something that is a pretty well-established way of conducting business all the way back to 1987, South Dakota versus Dole, when we attached conditions about the drinking age to federal highway funding. And you can argue about the policy cuts that were made, but at the end of the day, grounded in the statute.
So before I ask my questions of the panel, I do want to give Arpan a chance to give his responses to Michael and Christopher's presentation.
Yeah, absolutely. Thanks so much for having me. In the spirit of commenting in an intellectually nourishing fashion, I want to say that my remarks today are my own, don't reflect those of the chairman or the FCC. So I think that there are three broad questions over which there is some basic consensus on the topic of federalism. The first is, as an economic matter, does state regulation of an inherently interstate market have counterproductive side effects? I think there is consensus that the answer is yes in some or many cases. Then there's the empirical question about whether some states do in fact have the political incentives to behave badly and overregulate interstate markets in a way that could be counterproductive. And here I think there is also consensus that the answer is yes. You don't just see it with states trying to circumvent the deregulation on Title II. You see it with state regulation of VoIP. You see it with state regulation of how providers can enter and exit markets, which the FCC expressly regulates under Section 214 of the Communications Act. You can see it in states imposing per-line charges on mobile subscribers under their USF programs. You can see it in a wide variety of areas, and we would expect that trend to continue purely for political reasons. And then finally, there is a legal question about what it is that we can do. And I think there is a consensus that there is no consensus answer on this. And it's not something that, I'm going to weigh in on from my perch, when folks smarter than me have already told us that this is something that we're going to have to continue to look at. And that's sort of where, when we're talking about what if anything the FCC can do about that, that is a conversation that we'll need to continue to have. So ultimately, I think that to a large extent, this is going to be a political problem, but I want to put a couple of questions out there for our speakers, and maybe they can address it in final remarks. The first is, we talk about different conceptions of federalism, dual federalism, cooperative federalism. But, to me, stripping away those academic words, the question for me today is, what are states really good at when it comes to telecommunication policy? Where do state PUCs have comparative advantages over federal regulators? I think that's a question that we'll have to think about from first principles. The universe of such areas may be exceedingly narrow, right? So when you think about something like cable franchises, you think about some of these legacy approvals, they exist in spades, and I guess there's a question about why they need to be involved in that. So I don't express a definitive opinion, but I do think that it's worth asking that question. The second is what sort of model that we think BEAD falls into. I don't think the federalism picture with BEAD is also clear. You think about two examples. We'll think about the Virginia example, where Virginia did not want to put in price controls, and they are ultimately jawboned to do so by the previous NTIA. So that's one form of discooperative federalism. And then you see a California example where it goes above and beyond some of the federal guardrails that were in place and are able to sort of regulate in a more untrammeled manner. And so those are both problems, but they're sort of pointing in the opposite direction. And so I wonder how we have a vocabulary to describe what's happening in that situation. Then let me also sort of throw out for consideration some of the progress that we made on infrastructure back in 2017, 2018. As you know, that was then Commissioner Carr's sort of signature effort. He took over that infrastructure docket, and there were a lot of state and municipal laws, mainly driven by NIMBY interests, that would, impede the tower siting and small cell deployment. And we took a series of actions relying on our preemption authority under 253 and 332. Most of those efforts were upheld in the courts. There were some that have been sent back down, but mainly for notice issues. So in the main, that was a successful initiative. I wonder if there are any lessons that we can draw from that experience, not just from a legal perspective, but in terms of a political sales perspective as well. So thanks for the presentation, and I look forward to continuing the conversation.
Great. Thanks, Arpan. Before we move on, I want to ask a policy question about conditions on BEAD funding. The explicit premise of this legislation is that these are areas that would not get broadband, high-speed broadband, in the absence of federal subsidies. So by definition, those federal subsidies are going to fund a monopolist in the relevant area because the decision's already been made that nobody else can provide that service. Now, bracket whether LEO satellite changes the equation. Assume that it doesn't. The federal government is then subsidizing a monopoly provider of broadband services. Why shouldn't it regulate the rates that are charged? The government always regulates the charges imposed by monopoly providers of communication services. It has always done so. I can't think of any universal service program in the past where the government didn't regulate the rates charged by a provider who receives funding to serve otherwise unserved people. Am I mistaken about that?
So
I'm looking at Misty.
Go ahead.
I'll let you go.
No, I'm going to puncture the premise of the question, so go ahead.
So I agree that yes, it is a grant program and the larger philosophical, and the feds have the right to put whatever parameters they want around that contingent on you getting that money. I always tease the companies. Uncle Sam calls it free for a reason. If you look at the parameters, they're going to make you work for it in some regards. However, to your point, John, the premise of BEAD is it's closing every single location. If you look at that NOFO and the underlying policy premise, which Congress actually got right, is this is intended to serve all those folks that are never going to get internet otherwise. This is where the government's got to help that free market. And so when you add on more disincentivizing regulations and add-ons, you're not going to have those folks even come to the table where I can spend the money. And I'll give you an example that we're dealing with real time. So we had the ARPA program in 21. My governor allocated $300 million towards broadband. I got over 80 applications and $1.5 billion in interest. Those of y'all that are familiar with ARPA essentially said, go make broadband. Godspeed. Go get it out there in the ground. BEAD only got $630 million, even though we lag pretty far behind in the country. And 10% of my locations are 72% of my spend. I got barely 40 and 500 million. And every single company cites they cannot meet the charge and go out to these areas where it's so rural, it's so remote, it's so hard to build, and also meet the intent of the regulations. So I agree that the government does have the right to put those in place, but if we're really serious about reaching those last locations, I think that's where DC got this wrong. They're not understanding how it works in the states and what our companies, big and small. I've heard this from our big clients and our smalls, that it's really hard to meet and balance those.
Nick?
So working backwards, the statute says that NTIA shall not rate regulate, and you can ask Alan Davidson this question when he's here later today, but I will go to the mat and say that does not, there's no rate regulation in the BEAD NOFO. The prohibition on rate regulation is in the same section of the statute as the section of the statute that says there shall be a low-cost service option. So the pure logic says that low-cost service option can't be rate regulation, because how else could they be in the same place. With all that being said, Ms. Deanna is exactly right that different states have different challenges, and coming back to Arpan's comment about thinking about these things from first principles, the statute set forward a very straightforward allocation methodology. Said, go look at the national broadband map based on the number of unserved locations in each state. Everybody gets $100 million to start, and then the rest of it you dole out based on the number of unserved locations. That's what the statute said. That's how Misty got her budget. Is it the budget that she needed? We'll see at the end. But
No.
there were quite a few. The NTIA didn't have the flexibility to say, oh, wait, Montana actually needs more money, so we're going to take some from Louisiana and give it to Montana. That's not the way the statute operated. The second step is that it allocated that money to the states, and it said, here is a set of uses that you can use the funds for, 60102F of the statute. The first one is unserved and underserved service projects, and it does require that those get done first. And then it says address your community anchor institutions. And then there is another list of things that the states are allowed to do with that money that is left over after they get done those first two things. So when we talk about the fact that there are non-deployment funds that are a slush fund, that's not what those are. Those are the funds that are left after the state has accomplished the first two funding purposes that they were obligated to do under the statute, and the remainder is theirs to do within that 60102F framework, which includes, by the way, Chris, broadband adoption. So
Could I jump in?
yes, please.
Just a couple of thoughts real quick. So on the rate regulation thing, we've argued that putting the rate regulation question aside, I mean, you can attach strings, but they can't be tantamount to a gun to a state's head, as we saw in the healthcare cases, the Obamacare cases. And we've argued that NTIA was coercive of the states, like of Montana and others that had voiced very serious concerns, and they really arguably gave in to get the money, which is critical, which is needed to get broadband to every part of the state. And the notion of regulating rates in areas where there's only one provider, the difference between BEAD, the difference with BEAD is that it's a one-off grant. Whereas in the past, like universal service programs have been ongoing subsidies to make that business case in those rural areas where now the providers that are going into these unserved areas need to make the business case on their own, so they need to set their rates appropriately. So if you price them too low, if you say you can only offer whatever, $30 or $50 a month, that's not really going to help them afford and make the business case to serve those areas in the absence of potentially ongoing subsidies, which I don't think has been discussed.
Well, that's the big point. So there's a paper I wrote a while ago, which some of you are aware of. There's a big fight over broadband funding, and the big one was about Muni Fiber. And there's all the reports have been done by different interested lobby groups. One group cherry-picked the worst examples, one cherry-picked the best examples. So I said, the only way to do this academically is to take all of them and do a systematic analysis. So I took all the Muni Fiber bills in the world, in the US, and looked at their audited financial statements. This is the stuff that people invest in. This is the stuff you go to jail where you lie about them. All data are wrong. Some are useful. It's the best data we got. And what I would say, I can give you the specific numbers. It's been a while since I've looked at even my own study, and it's getting old. But there were sort of three categories. There's ones that were breaking even, both in terms of covering their operating costs and recovering their capital costs at a level where they're going to be fine. There's a middle group that was operating in the black but not generating enough surplus to cover the investment costs. And there was a group that was operating in the red on operating costs as well as capital. And if they're on the negative on the operating costs, they're never paying back the initial investment because they have nothing to pay back with. And to me, rate regulation has to take this into account, which is, there's a bunch of places out there which yes, these are going to be monopoly facilities, Jonathan, and that's the question. But the problem is, if they're already operating in the red and we're going to constrain the price that they're charging, that's going to be a huge problem.
Right. So it sounds like, yeah.
And to get to the point that Michael made, they're very clear, and our US used to say this on the things that they've been subsidizing for years. There is no operating cost model. They depend on USF funding on an ongoing basis. So yes, there are huge amounts of this where this is BEAD sort of presumes a one-off. That's not the case with a lot of these areas, and that if it's not accompanied by a plan to provide the missing funding, these things are going to die.
So I'm going to make the suggestion that there's less disagreement here than meets the eye, because I think everyone agrees that under the statute, the ISPs who are the recipients of this money have to provide a low-cost option. And so really the question is, how low should the price ceilings be, and how long should they last? I mean, the issue does get into those details. So I want to pivot a little bit to another area of controversy about BEAD, which involves the prior administration's focus on fiber as the preferred medium for broadband. I'm going to read a tweet by somebody from, and then I'll leave it to the audience to suggest who it might have been, who tweeted this past June that the BEAD program, quote, is an outrageous waste of taxpayer money and is utterly failing to serve people in need. And that same person retweeted at the same time a post saying, for $42 billion, they could have bought Starlink dishes for 140 million people. So any guesses who the tweeter was? Okay, so I guess the question, that tweeter is now in a position of extraordinary influence and power in Washington. As far as I know, he has not recused himself from any proceedings regarding broadband funding. And so my question is, what should we expect? And obviously these are all wild guesses, but what should we expect from the new administration in terms of a change of priorities for how the BEAD program is implemented? And I'm going to turn to Misty Ann again first.
Can I put money on who the tweets from? Is it a betting scenario? I'm a betting woman.
No one's going to take the other side.
So obviously, yes, the landscape has changed. And when we talk about budgets, and Nick is absolutely right about the funding formula. And when you hear me talk about lack of funding, Montana is one of those states under the current NTIA NOFO. We have an $800 million deficit. So you will hear that from more Western states now. Who knows how this is going to change, especially when you do talk about satellite. And so what we've been advocating in a lot of our sister states across the way with Congress and with folks in D.C. is let's kind of end the shenanigans of an all or nothing approach and let states figure it out. We have great competition in Montana that is not fiber to fiber. It's not fixed wireless. It's not satellite to satellite. It's all three. I'm even a consumer. I was telling Chris this earlier that I gave up fiber because I'm never home. Why am I paying $150 a month so I can check email when I get home? I went to fixed wireless. It works just fine. Let consumers pick that. And Montana is fortunate enough that we have satellite and we do have fixed wireless, but we don't have fiber to the home everywhere. But I think it should be state by state. And what we're hoping that the administration changes is not let's just give it all to satellite and then the problem's over. But it's more that flexibility, because the challenge we have, at least in Montana, is there's a lot of income disparity, same in most states. And so satellite is fantastic. I know a lot of people that love it in Montana. However, have you ever looked at the price tag of it without the government subsidy? Most folks can afford it. It is a luxury option. And I know the markets have got to figure that out. Both companies are fantastic. We were talking about this earlier, that it took, Dish and all of that 15, 20 years to create that really competitive market and get more in the mainstream. And I think we'll see some of that over the next few years. But I don't have a magic 8 ball, but I know a lot of us states are advocating for just total neutrality in terms of it's your state, you know what's best, you work through it and figure it out, and just tell us what you figured out on the backside of your homework. So,
okay.
So, go ahead, Nick, please.
No.
Nick,
you matter more.
I'll just say two things. The first one is that satellite was always contemplated as part of the solution under the BEAD program. The statute does have a definition for priority broadband projects, which the NOFO does say is a fiber end-to-end solution. But if you look at the language in the priority broadband project definition, you have to squint your eyes and tilt your head pretty far sideways to see low Earth orbit satellite as part of the priority broadband project definition. So the statute did push towards fiber or something that looks an awful lot like fiber as the priority. The NOFO also created the mechanism to allow the states to find the technology mix that works for the state. I can visualize from very early in the process charts that we would put together that, based on different policy decisions that we made, here's the curve for where the fiber goes, here's the curve for where the fixed wireless is, and here's the upper corner where the satellite is, because we know that there are locations at the end of that hockey stick that are not going to be economically feasible for a fiber or even a fixed wireless deployment. So the program always contemplated satellite. what I hope as we move through, and yes, there is clearly interest in getting satellite more involved in the program, is that we don't kind of throw the baby out with the bathwater. There are things that one could do very easily at the federal level to allow the states more flexibility as they move forward, more flexibility than they already have with respect to setting, and I love this, what they call the extremely high cost per location threshold, which is where they can cut off the end of that hockey stick. But if we were to go back, if the federal government were to go back and require a fundamental revision to the way that the subgrantee selection process operates, you would take states like Montana that have already moved the train well out of the station and have them go back and conduct another process that would be a disservice to the residents of those states that had aggressive state broadband offices that have reached reasonable solutions where they are now.
So actually, I need to do a quick housekeeping check here because we started 18 minutes late. Theoretically, the panel's ending in 2 minutes, and we haven't asked the audience to ask questions yet. I'm assuming that there's some cushion built into that 20-minute interval between 11:40 and 11, right? Your advocacy. Yeah. Okay, that sounds good. I do want to, we can get back to the fiber priority later if it comes up in a question, but I want to pivot before opening it up to questions to one more question about preemption. And this goes back to the net neutrality set of issues. So ISPs are now deemed by the Sixth Circuit and what will likely be an authoritative ruling to be unregulated information service providers. Who else is an information service provider that provides interstate services? Well, a whole lot of internet companies are. Big tech is. Google is a Title I information service provider. So if we think that something about federal law preempts state net neutrality regulation of ISPs, is the logic any different for federal preemption of state neutrality regulation of Google or other tech companies? And so I will open that to discussion, and I am happy to hear anyone's thoughts on it.
So what I would say is this is going to be a treasure hunt, and it's going to be trying to find a provision that can provide the hook, and then arguing that ancillary jurisdiction will take you far enough to do that. So the thing that's sort of sitting out there that is a little bomb, I went through all of Title II. There were some things at Title III sitting out there, so they're a little bit different. And so the question is, could it be different for a wireless space, wireless broadband, mobile broadband, than it could be for, or even fixed wireless, than it could be for, it all depends on the statutory hook and what you can argue. I mean, and that would be a pretty irrational thing to do. Right. But, if that's the world we're in, that's going to be tough. And you're going to see a huge fight, I think, exactly about what you're saying, which is Chairman Carr has made pretty clear that he would like to expand the attention of the SEC to the internet companies. Yes,
he would like to regulate the neutrality of the internet companies, as I understand it, based on what he said in Project 2025 and also in some of his subsequent statements.
But to retreat back to Brand X, in a Chevron-based pre-Loper-Bright world, said just because you're classifying as an information service provider does not automatically mean it's deregulated. That has been the heavy presumption. But they left open, the court said this could be an area of doing it. Now, in a post-Loper-Bright world, it all depends on us finding that hook. Mm-hmm. But to automatically equate categorization of information service with complete deregulation, I think, is moving a little too fast.
That's true. I mean, the Ninth Circuit did say that there might be such a thing as an intrastate information service. This was in California 3, I believe. I'm not sure what that thing is. Maybe back in 1993, voicemail qualified as that. But I think everybody would agree that search engine services are indivisibly interstate. So if there's something about a service being both an information service and indivisibly interstate that preempts state public utility style regulation, it would presumably have to apply to that preemption would presumably have to apply also to state regulation of tech companies.
As of right now, there are some active cases that have sought to declare Google to be a public utility under state law. They failed not because of preemption, but they failed on the merits. And so the answer is, as of right now, the perception of state AGs is that they have the opportunity to at least make that argument. Whether they can make it under substantive law is not because they lack jurisdiction.
Okay. Thank you. It is time to open up the floor for questions from the audience, and I will apply the Phil Weiser rule, which is a student goes first. So do we have any volunteers from a student to ask a question? Yes.
Thank you. Thank you for the enlightening discussion. This is for Professor Yu. My question is there any statutory basis that the FCC could use to preempt net neutrality rules in states? And my next question is, notwithstanding the legal challenges that could ensue, could the president pass an executive order that effectively preempts states from passing net neutrality rules, or would this require action from Congress?
So, easy answer to number one. In my remarks, I haven't found it yet. Doesn't mean it doesn't exist. As I said, there's other statutes. We can go through this and we can construe it. And then there's the question about the breadth of ancillary jurisdiction. And because everything affects everything, there's some ability. We know that the FCC has lost some ancillary jurisdiction cases. So there's such a thing as a bridge too far. There's going to be a lot of effort on this, particularly if the states get extremely active. On your second question, there's a difference between whether they can or whether an issue, such an order could issue, and whether it be legal. So the answer is, there's no question to me that this administration is very active at issuing executive orders. At the end of the first Trump administration, he ordered at the beginning of a Section 230 rulemaking at the FCC, which was then wound down. Many people weren't sure that was within the authority, whether it was a good idea. I think we may find out. But the federal government, the president, unless you believe in something we think of called inherent presidential power, which goes to another world I lived in and wrote a whole book on called the unitary executive, even people who are in favor of fairly strong inherent executive power believe it has more to do with caretaking the executive branch and overseeing the executive branch. It doesn't actually give an independent source of authority. And there's just some very minor arguments. So much as agencies have to be given authority by Congress, executive branch, in its core, aside from this inherent executive power, executes authority that Congress has given it. And if it's not given to the FCC and you can't find a statute that gives it to the presidency, the executive order would probably be challenged and have a pretty good basis for being challenged.
All right, next question. And if you could identify yourselves when you ask the question.
Sure, Rick Zimmerman with NCTA. So, of course, we have teams of lawyers working on the very question about preemption and et cetera, but I'm not a lawyer. I'm a policy guy. My job is to go convince state legislators and regulators why they should not regulate in the manner that we're talking about. So we've touched on it here in this session, but I want you to help me do a little bit of a deeper dive as to why state legislators should not engage in net neutrality or price regulation of broadband. And that's for anyone, but especially Nick. No. But
I don't think you can afford my billable rate anymore.
At Silicon Flatirons, we give free advice.
Oh, there we go.
Feel free to give a nuanced answer to that question.
I would refer you to Michael's remarks at the beginning. I thought that he provided a pretty straightforward overview of what the parade of horribles is that is supposed to result from state regulation.
Here's my advice to you, Rick, which is I think that what you see, I'm going to actually always compare to Europe, and it's usually to make fun of them and to show how we're doing better. Right now, Europe has crappy networks, and they regulate the hell out of them. And they regulate new builds and it's showing up in negatives to the point where in September, the Draghi report dropped an issue and said, we're behind the U.S. in productivity. We have to change. We're doing things. And when I look at this, it's not just there. I see this, if you don't follow this, the UK just fired its the head of its competition authority because they thought they were obstructing business. You get the messaging out of Davos from like the German finance minister saying, we need to make it easier on business. There is a moment right now, and the Trump administration is the incoming Trump administration is a great example of this, of trying to think about how to unleash this capability to make it better. Because the problem we're seeing in Europe is all the new rules they passed, it's causing services not to deploy there because they can't comply. and it's not punitive. It's just, and Copilot hasn't deployed there, OpenAI hasn't deployed there. Apple AI, and in fact, they're having to, Google's having to roll back innovations that they deployed there because they can't make them comply.
Yeah, let me add to that. I think we're in a zeitgeist right now that might be characterized by Mark Andreessen's famous essay a few years ago. It's time to build, right? After the last 4 years, there's an appetite to build more housing, to finish the projects that were started over the last 4 years, to get BEAD done, to get shovels in the ground. There's an appetite on infrastructure, and even states like California are starting to understand that. You can see that in their housing reforms. You can see that in a fundamental rethinking of environmental permitting. So I think that this is an opportune time to carry that message, which I think is also resonating among center-left folks. And, you know, I think may be persuasive even in the state houses that you may not expect.
I'm sorry, just real quick. So yeah, I think a big argument to make is you're already starting to see harms. AT&T leaving New York is a very tangible example of how these laws have practical impacts. As someone who lives in New York and has tried to talk to policymakers, it's hard to convince them that they're wrong. But that example could be very powerful in many other states. And then also another argument too is that rate regulation that we're seeing is, on the slippery slope towards utility regulation, which states have done for a very long time, electric and water and gas. And those are very onerous, exacting, and not suited at all for competitive markets or for monopoly markets. So if you can go to a state and say, if you want one provider in your state, then you can regulate them as utilities. Otherwise, you have to support and account for intermodal competition, which has been a hallmark of this space for decades.
Okay, so we only have time for a couple more questions, and I'm going to reserve the next one in the interest of ideological balance to a representative of the public interest community to ask a leading question about things that we've said. Any consumer groups here? Yes.
Hi, Chris Lewis, Public Knowledge. I guess, how about this one? Christopher, you said there's no roadmap for broadband adoption. Would anyone beg to differ, given the vast growth of thousands of people on the ground doing digital inclusion work, and the fact that Pew studies have shown that one of the greatest barriers to adoption is affordability, and there's been great investment in affordability, although a retrenchment with the loss of the ACP program?
No, I think that, I don't mean to say that's an overstatement. It's an overstatement to say there's not been a lot of great work. But we need to systematically put it together. I mean, they need a game plan. People are deploying this in this. They need to understand, okay, something that I've been working in, digital literacy. We don't actually understand what a digital literacy curriculum is. We don't actually understand the modalities of whether it can be done online, which would reduce the costs immensely, whether that's effective. We don't understand the duration, the follow-up, and and before we do that, we can't actually develop the lesson plans that we could share and give someone a turnkey solution to this. So there is a lot of good work. The problem is it's kind of ad hoc, and no one has really pulled it together in the way that people would like.
So one last question. I saw Blake, you had your hand up earlier. Do you have a question?
All right, Jonathan, this is to your provocation about a leading public interest question. I want to challenge the premise that you started us off with, that this is now a sort of stable ground that we're going to be doing state level regulation with respect to net neutrality. You talked about the Sixth Circuit's decision, which is, I think, just wrongly applies Loper-Bright. It says that the statute has plain meaning, which contradicts the part of Brand X that Loper-Bright didn't overrule. Are we going to see this movie play over again in 4 years if there's an administration change, with an effort to relitigate the threshold questions about the FCC's authority? And even if there's not an administration change, might we see the FCC eventually come back around to Title II and try and exercise some forbearance, recognizing all the shortcomings of the preemption approach, given Congress's dysfunction, et cetera?
So there is a great question about what the retroactive effect of Loper-Bright is. And actually the Sixth Circuit decision is the first one that one of the first ones I know of that actually gets to it. Things that have gone to judgment and are final are final. So in other words, even though there's a new standard, we can't go back to the 2015 order and the 2010 order. Why? The appeals have run. But the difference with the 2024 order is it was still a law. You use your best law at that time and apply it then. So in terms of, are we going to see this over and over again? If they hold that, and it makes sense to me, that based on basic principles of finality are general, you cannot reopen this decision 4 years from now because the appeals will have run. And in fact, under under res judicata, you're bound. The parties that litigated are bound. And so in fact, that door is closed. And so I don't think, as I'm worried about that swinging door being open if we interpret that in the way that I think the Supreme Court intended in the way that the Sixth Circuit did.
Well, that will be our last word. Thank you very much to our panelists.